So good evening to all of you and welcome. We are here for the book launch of the book that is titled Privacy, Right and Data Protection, Trust, Overreach and Erosion. The author, Dr. S. Chakravarti, Honorary Visiting Professor here at ASTI. I'd just like to say, of course, we deal with data all the time. All of us deal with lots of data, copious amounts of data. Everything we touch, whether we send or receive, creates a data point. And therefore, this is a very apt topic. And before I request several dignitaries that we have here to come on the dais, just share a small point from maybe a personal or family perspective. In addition to just comparing this program, I'm also the author's son, and my brother is also here, and we've seen a lot of work that our father has put in. We started work on this 3 years ago. There was a big pause due to my mother's illness at the time. And then after she passed away again, obviously there was a big pause. But to his credit, he's got back on it and put in a lot of work in the last 1 year. And so he certainly is an inspiration to us, at least the children, in terms of the effort he has put in, particularly at the age of 86 or not 87. I would now like to request the dignitaries. I would call each of them. First, I would like to call the Chairman, Court of Governors, Administrative Staff College of India, K. Padmanabhaya Garu, to kindly come on stage. And I would also like to request our chief guest, Shri S. Krishnan Garu, Secretary to Government of India, Ministry of Electronics and Information Technology, to kindly come on this. I would now like to request our panelists to also come on the stage. I'd like to first request the Vice Chancellor of Nalsar University of Law, Professor Sri Krishna Devarao Garu, to kindly come on stage. Now I'd like to request former Judge, Andhra Pradesh High Court Justice PNC Rangarajan Garu, to kindly come on stage. I'd like to request our final panelist, Sri M. Gopalakrishna Garu, Distinguished Civil Servant, former Chairman of SCOPE, to also come on stage. Now I'd like to request the Director General of ASPI, Dr. N. Ramesh Kumar Garu, to kindly come on stage. And finally, we'd like to request the author of the book, Dr. S. Chakravarti, to kindly come on stage. To begin, I would like to request the Director General of ASPI, Dr. N. Ramesh Kumar Garu, to kindly give a welcome address and remarks.
Eminent guests on the dais and distinguished invitees, friends, and well-wishers of ASPI. Today is an important day. This is one of the seminal occasions when ASPI had collaborated with Dr. Chakravarti, who worked long in Competition Commission at the time, to author a book to raise the debate and awareness with regard to the critical issue of privacy. On this occasion, it is apt to recall Justice J.S. Puthaswamy Gowda, who breathed his last only on 28th of October, barely 2 weeks back. His crusading spirit had really created a lot of difference, and it created a tradition in case of freedom and also right of privacy. To start with, as you recall, Justice Gowda had questioned the validity of the Aadhaar Act itself at the time. He felt it was an intrusion into the individual privacy. And the Supreme Court had upheld 4-1, a split decision. And the dissenting judge being the retired Chief Justice, Mr. Chandrachud. At that time, the court, while upholding, set 3 principles with regard to the right of privacy: the law, the validity of the law, the conflict of law, applicability of law. which continues to be the benchmark by which the privacy standards are to be tested. Aadhaar itself is one of the singular achievements by any stretch of imagination. And we have none other than a distinguished chairman of Aadhaar sitting among us, J. Satyanarayana. We have created a world-class architecture which is unparalleled, which has security features which are unparalleled, which are beyond the pale of reach. Such being the case, the issue arises, why is that Aadhaar could not be extended to an extended realm of public service because of the visible benefits it would bring by adoption. That is where the conflict lies. The issues of public good that would arise by adopting certain measures and the issues of privacy, which are intrinsic by its very nature, definition, and philosophy. Aadhaar had been successfully adopted for adopting many of the DBT programs, direct benefit transfer, which is directly happening and we are all beneficiaries. Whenever gas, when we do, immediately we get the credit entitled, which is that is for us, for the urban elite, for the rural elite, be it in the case of the farming sector, in the health and other sectors. The benefits of Aadhaar are visible, but at the same time, the Supreme Court had certain reservations with regard to the data privacy. So it had struck down certain sections of the Aadhaar and it was made applicable. So we have a limited applicability of Aadhaar balanced against privacy, which again was tested by Justice Puttaswamy Gowda when he raised the issue whether right of freedom is a fundamental right. This time the Supreme Court had constituted a 9-member bench because there was a 6-member bench and there was an 8-member bench which had given certain opinions which are being tested on that occasion. So it became a 9-member bench. And unanimously, the 9-member bench of the Supreme Court had resolved that right of privacy is a fundamental right. They have not created a new right, but they expanded the scope of the Article 19 in doing so. And what is significant here is the role of Justice Chandrachud. In the process of validating his own judgments, we had set aside the ADM Jabalpur versus Prashant, whereby senior Chandrachud on that occasion said the fundamental right stands suspended in terms of national emergency. But this is an occasion where the bench had, and Chandrachud had said that the fundamental rights can never stand suspended. They will always be in currency. Normally in Bible it is said, the sins conducted by the fathers will visit the children. This is the case. The piousness of the son expiates the harm done by the father. It's such rare occasion and it is to be remembered. Be it as may, I would not like to delve too much deep into it, but I had an occasion to deal with the Aadhaar itself and right to privacy. The Election Commission is one organization which is right in the epicenter of this debate. Simply by adopting Aadhaar, the anomalies in the electoral rolls can be done away with. The number of electors have more than one vote, willingly or unwillingly. I would not like to comment about it, but this is incorrect. They cannot be manually removed, but by adopting a finishing methodology like Aadhaar, it can be done. But if you were to do that, the philosophical issues of privacy would arise. This data pertaining to the billions of voters will have to be housed elsewhere, away from the Election Commission itself. This would raise issues with regard to the integrity of the election process. And unfortunately, there is not maturity or consensus in these areas. We continue to raise issues with regard to the wonderful practices like the EVMs, which are world-class technologies, which we should be proud to be associated with. This book is an occasion to raise the debate with regard to the conflict intrinsic with regard to the privacy and the visible benefits that would come. The other area is the Secretary Mikey is here, he should comment upon. We are all victims of scam phone calls and messages, cybersecurity threats, and so many things. And this, despite Government of India taking a conscious decision to block equipment from certain countries and certain places of manufacture because of the compromising feature they contain. The armed forces, for instance, don't allow members of the armed forces to use devices which are manufactured elsewhere. So these are real issues. These are real issues of cybersecurity and threats. And I am not qualified to speak. And the Secretary Nike is here. He is more qualified to enlighten us and to talk about this. With these few words, I would compliment Dr. Chakravarti for coming out with a very seminal and a timely book on an issue which has been engaging us at an individual level, at an institutional level, and as a country. And we have to find solutions together, which are not easy. We have to balance the private concerns of privacy and the concerns of larger public good. And this is an effort. And I extend once again a warm welcome to the many distinguished personages which this meeting and this book had attracted. Thank you very much.
Thank you, Dr. Ramesh Kumar Garu. I now request Chairman ASCI, Shri Padmanabha Garu, to give a flower bouquet to our chief guest, to S. Krishnan Garu, and also to the panelists. The first to our chief guest, the S. Krishnan Garu. I now request Sri Padmanabha Garu to give a flower bouquet to Dr. Sri Krishna Deva Rao, Vice Chancellor, Nalsar University of Law. I now request Sri Padmanabha Garu to give a flower bouquet to former Judge Andhra Pradesh High Court, Justice P.N.C. Rangarajan Garu. I now request Sri Padmanabha Garu to give a flower bouquet to Sri M. Gopalakrishna Garu, distinguished civil servant. Thank you, sir. I now request Chairman Court of Governors at ASCI, Shri K. Padmanabha Garu, to address the audience with his opening remarks.
Dr. Chakravarti, the financier of this evening, Mr. Krishnan, the chief guest, and a very distinguished panelists on the dais, and all distinguished invitees, amongst whom there are many colleagues from my service and other friends. So a very warm welcome to all of you. There are four other speakers after me. One speech you have already heard, so I don't want to waste much time. I just want to mention that ASCI is not in the business of publishing of books. So, but I have made an exception and published two books by the same author, one earlier on competition law, and now this book, which is before you. I have seen Dr. Chakravarti working every day for the last 1 year, from morning to evening, in a slightly dark room because the lighting is not very good in that particular room. And the amount of effort he had put in writing the book, I have seen personally because I come here every day. So the chap is also there. Incidentally, he's my batchmate and the IAS. I admire his commitment and congratulate him on at least bringing out this book. But I must tell you why I have made an exception and done this. Because both the books he has published are very, very relevant to the administration in the digital age. So we thought, even though ASCII is not in the publishing business, we must publish these books. And I'm sure we'll publish more books in future also. I just want to make 4 or 5 points. Earlier, we used to say that knowledge is power. Yeah, it is power. But having control of data, mainly personal data, is a greater power in commerce, in economy, and also in political fields. But what are the sources or repositories of this data, the personal data? Where does it come from? It comes from governmental agencies, like the tax data, from the banks, from the hospitals, from the voters lists, special surveys being made by the government every day. Example is the Telangana government, what is it called? Caste census. But you must see the length of that, this one questionnaire which is being given. It would take 2 days for me to complete that. So this is the amount of irrelevant data sometimes being collected. I mean, they said caste data, you ask me my caste, I will tell you what it is. Why do you have such a long this one, But all this goes into some silo somewhere. So that is one source. The other source is data which comes from the e-commerce sites. You buy things, you go and ask for some pair of shoes or a furniture or something. So your bank details, your age, everything, your profile, all those things are there with them. The third source is data maintained by the social media, like the Facebook. And also now from the OTT platform, Netflix and Prime movies and all that. So they know your taste. So if I see a war movie, they would tell me these are the 10 other war movies you must see. So if I see comedy, they would say these are comedies you must see in future. So they know your taste. And if you are a crazy fellow, they would show you some crazy films also, the point is out. So this is the way these things work. So these are the 3 sources. Especially the sources are collected and the information from these sources and presented or processed by the big companies for various purposes, including influencing commercial and purchasing decisions of individuals or to influence voting behavior. I would refer to this particular case again. There is something called the Cambridge Analytics case. Some of you must have been familiar in 2016 in the context of the elections to American presidency. So, as I said, I would give the detail in a minute. However, till 2012, in our country, no one paid much attention to the question of privacy of personal data and its protection. Then what happened in 2012, a reference is made by my colleague, Ramesh. One Justice Puttaswamy, he was a retired justice, he filed a writ petition in the Supreme Court against Union of India, arguing that the Aadhaar scheme excessively intrudes in the privacy of citizens and has scope for misuse and leakage of the personal data collected by it. That was the main thrust of that. So what happened is the decision took about 5 years, 2012 to 2017. In 2017, the Supreme Court held a 9-member bench that right to privacy of every citizen is a fundamental right under the Constitution. And that step should be taken to protect that right, subject to certain conditions like public safety, national security, etc. Of course, they held that the Aadhaar scheme is all right, as necessary safeguards against leakage or misuse of the private data have already been provided in that particular act. But the most important thing is that they held that privacy, the right to privacy is a fundamental right under the Constitution. That is the most important thing. No, remaining are not really relevant. Now, Government of India examined this advice of the court over the last few years and has now enacted the Digital Personal Data Protection Act 2023. The act has been published, but it has not been brought into force, not yet. The rules and guidelines under the Act are yet to be framed because most of the procedure would be prescribed by the rules and the other guidelines. But the basic principle is that private data cannot be collected and used without the consent of the person and can only be used for the stated purpose for which it has been done. These two are important. One is consent has to be there, and two, it must be used only for the purpose for which it has been collected. There is another aspect to the subject, that is uncontrolled or unlimited access to data can lead to monopolistic practices and would be subject to competition laws of the land. If excessive data is collected, then Google is the king of the search engines and all that. So Dr. Chakravarti's book deals with the subject of privacy rights and the personal data protection in its various aspects. I commend the book of Dr. Chakravarti for the reason that it had made extensive use of case studies. About 18 case studies he had studied, one or two from India, maybe more, but from abroad also. And these cases are again classified into three categories. These are called, he used that word, but in a common parlance, he had given some other name to that. But the three silos are good, the bad, and the ugly. That based on that American film. So he has divided these cases, the examples of 18 cases, into that. And for example, Cambridge Analytica, which is a company engaged in political consultancy and strategic communication. Consulting. There's something like our great expert from Bihar. What is his name? Prashant Kishore, something like that, And then they collected information from the Facebook. Not only the Facebook users, but the friends of the Facebook users. How much information did they collect? 87 million people's information, personal information was collected. And they roped in another person called Alexander Kogan. He's a UK-based academic researcher. So that fellow took the Facebook information and tried to analyze it personality-wise. What type of persons are these? Are they liberal? Are they conservative? Are they extra-liberal? Whatever it is. And all the three of them analyzed the American voters and then gave political messages addressed to them to see that they would vote. So this is the type of thing that has happened with that Cambridge Analytica. So he has given this example and he has put this in the silo, obviously the ugly silo, good, bad, and ugly. The third reason why I praise his book is he has included a chapter on privacy and data protection laws of 12 other countries. There's not only the Indian list. So I'm sure the book will be very useful to anyone concerned with the digital government, because we are now in a data-driven world. So I once again congratulate Dr. Chakravarti for his excellent work and wish him all the best. And I don't know whether he's going to write one more book, but let it go. So, thank you, gentlemen.
Thank you very much, sir, for your remarks.
Yes, the Aadhaar, this one, because it helps people, to direct benefit transfers and then all those things. So that goes into the first silo. The good, the ugly I have mentioned, and there are some in between. Thank you.
Thank you once again, sir, for your remarks, for your insightful remarks. Now we will have a presentation, a brief presentation of the book by the author, which will then be followed by the formal launch of the book by our chief guest. So I now request our author, Dr. S. Chakravarti, to make this presentation. Thank you. I'd operate the type. Mr. Padmanabhaya Garu, Chairman, Board of Governors, Top College. Mr. Krishnan, high profile Secretary to Government of India, Meiji. Mr. Krishna Rao, Professor, Vice Chancellor of the important law university in the country, top law university in the Nalsa, Justice Rangarajan of the Andhra Pradesh High Court is there, and Mr. Gopal Krishna, Muthusetti Gopal Krishna, who is a retired IAS officer who is specialized in public undertakings, and he was also chairman of the court. My dear colleague, Dr. Ramesh Kumar, who is a very close friend of mine and a well-wisher. And of course, all of you, I am overwhelmed by the fact that so many of my friends have turned up with their spouses also, and most of them are my colleagues. But I may add one thing, I am the oldest in this community. Who? Now, I'm going to show you a video for about 3-4 minutes before I latch on to my PowerPoint presentation. The trigger is what I'm going to show. You can see here, the video will be now shown to you. It's a conversation between two persons. One, a senior executive of a MNC, or a very big company. On the other side, on the telephone, is an individual who is a representative of a manufacturing company, who is also a senior in position, but not very senior. That's a conversation. So let's go to the conversation of the video first, then I'll give you my PPT. Right. This is the first head of that senior person, executive I told you, who is going to come and sit down and hear you.
What a tiring day it was today. Let me relax for some time. Hello? Hello? Who is calling?
This is Rohit, sir.
May I know why are you calling me? May I know the purpose?
I'm the representative of a pharma company, Medico, a reputed big company with presence all over India.
Why have you called me on my mobile? I'm surprised. You have my mobile number?
Sir, you visited the mobile phone showroom last month to get your instrument serviced and make it function error-free. At that time, you mentioned your mobile number loudly to the counter girl. The shop has CCTV which has recorded the conversation with the girl. The CCTV is interconnected to my head office at Medico. And you know what? They are our agents.
Why have you called me, Rohit?
Sir, I'm very pleased to talk to you. We have a new equipment for diabetes patients. We have insulin inhalers and smart insulin pens. Medico imports the same for the patients and hospitals, sir.
How do you know I am suffering from diabetes?
Sir, you have been a diabetic patient for last 10 years and you underwent treatment in XYZ hospital as recently as 2 months ago. Medico supplies medicines to this hospital also, sir.
It is ridiculous that my private health information is in the hands of outsiders like you.
Sir, you are a reputed executive in an MNC, and if you remember, sir, you have given a presentations to pharma managers at which you advise them to be transparent and ensure that all the health details are made available to the doctors who treat patients suffering from diabetes and germane indispositions. As my Medico Pharma manager came to know that you had treatment in XYZ hospitals, details of your diabetes conditions were collected and I was instructed to get in touch with you. Sir, the new equipment for diabetes may have some side effects, and those who have morbidities are prone to side effects. You have morbidities, and we have a drug to address your problem.
Who told you that I have morbidities?
Sir, a month ago, you got in touch with an expert physician who is a close friend of yours and sought his advice on morbidities.
Did you say that the expert is a close friend of mine?
Yes, sir. You and his family went to get together for dinner at Savoy Hotel. At that event, you paid the dinner bill in cash.
You know that too.
You forgot to bring your credit card to the get together event, so you had to pay the bill in cash. Even, sir, if you have bought the credit card, you could not have used it as the expiry date was already over and it needed to be renewed. May I send the new drug and new diabetic equipment to your residence? New one or the old one?
What do you mean, new flat or old flat?
Sir, your real estate broker informed the purchase details of the new flat to your bank and also the fact that you are planning to shift. I don't know if you have shifted, sir.
Hold on, Rohit. This is the damn limit. I will complain to the police. Either expect a call from them or a notice.
Sir, may I, with respect, inform you that there is no privacy law in force in India yet. A data protection law has been passed by the parliament recently but has not brought into force. Police, therefore, cannot act for the breach of data. Sir, even if the law has been passed, in your case, you have signed many forms when you are admitted to XYZ hospitals, one of which says that you consent to furnishing health data and other concerned data on your own volition unconditionally for such use as the hospital deems fit. May I organize reaching the new drug and new diabetic equipment to you? I am at your service, sir.
Disgusting.
Dad, do you know what happened in school today?
What happened?
They said that they don't accept a signature because it doesn't match with the Aadhaar card.
What do you say? My signature on your progress report does
Doesn't
not
match
match
with-
with my Aadhaar card.
Yeah.
Video you have seen, which sets in motion the discussion for today and perhaps my making a presentation of my book. You can see from this, I am plucking the fruit from what Dr. Ramesh said, as well as Padmanabhaya Garu, that the main decision was of the Supreme Court in Puttaswamy. You may be surprised to know that Puttaswamy case judgment is 1,400 pages long and the kind of a research analysis brilliantly done. In fact, I would like to say that Puttaswamy judgment can yield half a dozen doctorate theses. So I have plucked the fruits from that judgment as commencement points for my book. Personally, I'm not inclined to spend a lot of time on the theoretical understanding of the subject and also spend a lot of time on the legal aspects and implications of privacy right and data protection. I suggest that you may get a copy of the book and browse through the theoretical analysis therein. Before I proceed further, I would like to mention to you, you may ask a question. What triggered you to write this book? One is, of course, the video conversation you saw. I was privy to the conversation because that gentleman was a friend of mine. The two gentlemen who spoke on the thing, they're anonymized. They are both present here. One is Vivek, the other is Pankaj. Now, the trigger point was that one. The second was after a book launch, first book launch, about 4 years ago. One was P.K. Vishwanathan, former law secretary. He was present. And he said, Chakravarti Garu, why don't you write another book relating to competition law, but relating to some other subject also. So that was in my mind. I didn't do much about it, but I was reflecting. Then the third trigger took me. What is the third trigger? The third trigger was my wife, alas, she is now no more.
She was present at the first book launch, and she said, please put up your pen to paper to write another book because you have some exposure to certain things like not only competition law, but also data protection and privacy. So all these three triggers made me write the book. That's how the book has come into. Having said that, let me take you through the privacy right is a fundamental right is what I read. Please remember that all of you are giving data to so many people, but it's a fundamental right for you to have privacy. Don't forget that. It is because of Puttaswamy. This I told you, plucking the fruit. The features of privacy right, I don't want to go into in detail, but let me put it to you in very simple language. All of you go to, let us say, bank, finance institutions, airline, hospital, so on and so forth. There you are asked to give a lot of data. You give the data. You don't know what happens to it later. For instance, in AIMS, All India Medical Sciences in Delhi, 20,000, 30,000 patients' data were collected, purloined, and misused. That is the danger we have today when we give our data. Now, the reason why I'm bringing this into focus is in the privacy right, there are so many things here: dignity, liberty, freedom, so on and so forth, the right to informational privacy, and so on and so forth. But last one, the right to privacy cannot be impinged without a just, fair, and reasonable law. That just, fair, and reasonable law has been architectured and brought to force with the help of Mr. Krishnan, who is here as Secretary Government of India. Please give me a hand, please. I won't take much of your time. I'll be within my time limit, even though I got the weakness of being carried away by your own voice. Right. Now, the privacy right, I place them in three silos. The three silos are, I've given their name: trust, overreach, and erosion. Now, what is trust? I am putting trust as the reasoning of putting in three silos is rather like this. Many experts, practitioners, thinkers in our country think of privacy right in different forms. There's a spectrum. On the left-hand side of the spectrum, they say, oh, it's very good, it should be done. The other thing, oh, it is very tough for businessmen. I'm sorry, we will not be in a position to have this and have innovation, creativity, investment, and that. In the middle, there are a few people who say it's good and it's also bad. So trust is where it is all good. Overreach is where it's good and bad, and erosion is where it's ugly. So you can call it good, bad, and ugly, but I am putting as trust, overreach, and erosion. Now, in the first, I'll give each one of them only 2-3 clips and then close that down. The citizens have they have got the right of privacy. They value it all. But then, in welfare schemes floated by the government, like subsidies, subsidized cylinder, or free food, or any free call it that. For that, they get data from the poor people, marginalized people, and the impecunious people. All these people give data. They don't know what data they're giving, how it's going to be used or not used or misused, and they don't even know that they have a right. So with the result, so many people are giving the data. One can ask a question. If you are having this kind of a problem, then how is privacy right to be defended? I mean, the right is gone from these people. But then it can be justified because there is so much illiterate population in the country. You can't expect them to have a knowledge of privacy right and then say, oh, I will not give you because they want these subsidies. They want the welfare measures. So for the sake of welfare measures, you require this kind of privacy, even if it is demented to some extent. So these what, and the last bullet, sovereignty and integrity of the country are taken care of by this law itself. Now, I'll come to the next one. Again, the trust, again, the good one. This is again, I'm still on the left-hand side of the paradigm. Second is, you can, with the help of artificial intelligence, you can have good police administration improvement, justifiable surveillance, very important, not careless, immoral surveillance, but justifiable surveillance. For instance, somebody makes a theft, you are able to get them. You can use data to get that. That can justify surveillance, democratic administration, upscaling quality education, and finally, ladies and gentlemen, one thing which is important, even for farmers, the farming community, we can give soil management information and intelligence input. That makes the whole thing, privacy as a trust, is very good. So I'm giving you the plus point of this. Now, we'll go to overreach, as I mentioned, good and bad. Here, perpetrators could be private. Perpetrators could also be state government. I'm not saying all state government or government of India or any political party. That's not the things don't reach more than what else. But state has the capacity to get into surveillance and profile the thing. So that is the third. Now, these two things I'll give you slightly more. The overreach, as I mentioned, we have got lots of data. What is happening is the data which they collect, they make it into different products. For instance, put it this way. Uber, I put it Uber cab. Many of you are hiring Uber cab. You do the lady cab. All this. 200 people trade, give the tip. Now, what the Uber company does, or even some what is the platform, he doesn't collect data because it's with them, and then put them into different spots, segregate. What way? What is your preference? Supposing you are going in a cab regularly and you stop before a church, mosque, or a temple, it's noted. Now, all these people who have done this kind of a thing repeatedly, one who goes to a church or whatever it is, he is given that label of having a follower of that faith. So this kind of a thing, you are segregated into different groups, and then later they misuse it with whatever way they want. So even for elections, they give this group of 10, 15, 20 people are having this faith, and then the political party to take action. So that would trigger action against that. The point here is, even when a simple thing in Uber hiring, you are getting yourself involved in a situation where the data which you give can be. Now, I got a number of conditions here like monopoly, Amazon's music streaming, unfair condition, all these things are harm to consumers, damage to companies, all these things are there. This is overreach of one kind. Now, one more. This is misuse abuse of state. See, the Act says the state or its instrumentality. What are instrumentalities? Government undertakings, government cooperative institutions, government-based units, entities, maybe companies that got a subsidy and so on and so forth. Now, if the state, again I repeat, no reflection on anybody here. Any state, if it intentionally is not ethical, that's moral, but it crosses the Lakshman Rekha of legitimate and proper administration, then there will be misuse of administration. And finally, can harmful citizens are violative of moral standards. One case is air bonds. You see, I have given air bonds as one of the case laws in my book. You can read through them. How the data which is given, when who gives money to whom, the private somebody gives a political party can have a quid pro quo with the man who has given money. All this data comes in. Ultimately, that also can be misused. And that is the thing which I call overreach. That is where the law is there, good, use it for the citizens for welfare, fine, but there can be overreach. That is, the law becomes vulnerable to unethical acts. That is the overreach. Now, I come to the final point, erosion. Erosion is the word I used there, ugly. Why is it ugly? The reason is there are big tech firms, we call it Microsoft, Apple, Amazon, so on. It is so much of data. And what they do is they have got very intelligent people. They make it into sub products and they know which group of the customers are wanting a particular product. Call it FMCG or any other product or even rest. Then they are able to give to the manufacturers, oh, this group of people are having this kind of a preference. Once the preference is known, then they sell the sub-product of the data to those manufacturers, and those people start calling you. Hello, so and so, do you want this particular perfume? All kinds of things. Now, you get sometimes calls. You also experience. All that is because there is a group of people working on this kind of misuse of data. I get a number of case calls, Google Play Store, uncertain written, and Meta, WhatsApp, and such a thing. So be careful on this. I wanted to give you a general kind of advice, not a caution. Now, what India has done, they have passed a digital personal data protection 2023, which has been mentioned by the chairman and he also. It has not been brought into force. There is no private zero as of this minute. If it comes tomorrow, now, this weakness of the act I put here, and don't get into so much of taking this. The only thing is, I'll make it one important point. All of you, ladies and gentlemen, you're educated people, right? You're educated. You give data. When anybody is asking for data, please say that you must take my consent for a part of the data. When you say consent, must give the purpose for which you are getting data. Once the consent is given, purpose is given, then you tell them, whoever comes to collect the data, look, this is given under consent, but once the purpose is achieved, I will withdraw the consent. Then you can't collect, use the data, misuse anything of that kind. If you do, it's data breach, punishable under that. So the point is, whenever somebody comes to collect data, please ask them, take the consent first, take the purpose for it is given, and also remember, I have got a right to withdraw my consent whenever I need, after the purpose is. So, is what I said here. Data privileges you and I. Data fiduciary is a fellow takes the thing in his company and then it processes with data. Now, I told you about the consent. When we say the consent, how should it be? Specific, free, informed, unconditional, and ambiguous. Now, this is what I call very important as well to remember. Finally, there is a data protection board which will take care of data breach. In case you find that your data has been misused or abused, you can file a complaint to data protection board, and if board comes to enforcement, yes, you are offended, they will be punished. And the punishment is quite simple. And data breach is what I mentioned. Data with serious offense punishable. Now, the do's and don'ts, I'll go through very quickly. For the companies and firms, they must all prepare. Right on time or overrunning the time. Please give me under 5 minutes. You have to create a data privacy framework as a company. You have a framework in an office, a company. You are running a company. Have a good framework for data privacy. Then be aware of the need and responsibility to exercise control over privacy. Educate your employees. Then protect sensitive data through security policy. Comply with the act. Avoid policies which create entry barriers and factors. Avoid, very important. Avoid policies impeding innovation and technical development. Now, for individuals like you and I, the Act provides the protection and safety of data. Your consent is imperative. Is this on top? Remember that your data can be used in interest of sovereignty, integrity, and security. Very good. You can use it. When data breach occurs, remember, take action. Cyber security, please understand what you have to do. Now, what I have done is, since coming into the hall here, I thought of a few points which ladies and gentlemen, you would like to know. I just give a very small flavor of this. Remember, data, it is not the data that is being exploited. It is the people who are getting exploited, you and I. If you remember that, data privacy is a big concern for individuals. And there's a trade-off between data sharing and data privacy. One, avoid sharing. 2, share data with trusted brands and platforms. Don't go to untrusted. 3, anything posted online stays there forever. Remember that. You put it online, it goes in somebody. Then it's out of your control. So anything posted online, be careful. Beware of banking and financial fraud. And find 2, 3 small things. Remember, data stored in your personal device like mobile, you own it. That data, you own it. You are the owner of the data. Data should be shared with hardware, software people, that is owned by the providers of the service. Data uploaded on internet, it is in public domain, accessible to everyone. So remember this. This is the way in which data is going here, there. So if you don't mind this and take care of it, you will be the least. So that's the point which I wanted to make. For employees, if you are in a company, educate yourself first, then your employee, then take action for cybersecurity as such in the book as to what you should do when you feel there's a data. Then there's one thing which I mentioned, the person may kindly comment on the cases like this. Audit your privacy policy. That is, you have privacy policy in a company. As a government company, government entity, instrumentality of government, anything, you have a privacy policy. Get it audited. Am I doing the right thing? Is the privacy policy complying with the act and the rules and regulations? Please have a board. Repeat it, not once. Once in 6 months, have an audit. If you audit continuously, then you know where you are erring and you will correct it. So that is the thing which I want to mention here. And all the privacy policy, but other things. Now, as we say goodbye, I would like to say a quote. Life can only be understood backwards. You know what has happened in the past? You have done good things, bad things. You have been victimized. You have succeeded. You have understood backward all of it. But it was lived forward. That's what Howard Horn said, I quoted him. We need to move forward and live forward, not only look at backwards and keep it. That is my quote as I say goodbye. But before that, finale. Privacy rights and data protection are indispensable guardians of citizen freedom. All of you have the freedom to think that privacy and data protection will be required. And thank you very much for your attention.
Thanks to the author, Dr. S. Chakravarti, for providing some perspective on why he wrote the book and some interesting aspects of the book. And of course, you will learn more by actually reading the book. Now we will proceed to the official launch of the book. And I kindly request our chief guest, Secretary of the Government of India, Ministry of Electronics and Technology, Krishnan Garu, to kindly read the book. Let it. That's true. You can open to it. Oh. The open to. Yeah, thought we said. 1 second, stay for that. Yeah. Bring it here. Take it. Now, presenting a few copies of the book to the all the books we do, all the people. Presenting a copy of the book to the people on the dignitaries on the diet. You can show the book like this and get a photograph. Yeah. Request a group picture to be taken if all of you were to just hold your books up. Thank you. Thank you, sir. And now, before I request our chief guest to address the audience, just take a minute to give a brief about our chief guest. The S. Krishnan Garu is the Secretary to the Government of India, Ministry of Electronics, Information Technologies. Had a long career for over 35 years in Government of Tamil Nadu, Government of India, and the International Monetary Fund. He has served in many domains within Government of Tamil Nadu's finance, industry, commerce, etc. He's also been a senior advisor in the Office of the Executive Director of the International Monetary Fund, looking after South Asia, and also represented Government of India in the G20 expert groups on international financial architecture and global financial safety nets. So while he's had a very distinguished career so far, personally, I think the work he's doing now is especially very important. As Secretary in the Ministry of Electronics and Information Technology, there's an extremely important vision and planning that India is carrying in the areas of e-governance, the very important India AI mission that Sri Krishnan is heading and introducing, and paving the way for how India will navigate the AI world, as well as electronic semiconductor manufacturing, etc. So as much as he's had a distinguished career so far, what he's actually doing now is extremely important for India going forward in these very crucial areas. With that being said, I request our chief guest, Sri Krishnan, to kindly address the audience.
The chairman of the Court of Governors of Trustee, Padmanabhaya Garu, other eminent dignitaries present on the stage, including the author of the book, Dr. S. Chakravarti, the Professor Sri Krishna Deva Rao, Vice Chancellor of NALSA, Honorable Justice PNC Rangarajan, former judge of the Andhra Pradesh High Court, who informed me, and I was not aware of this before, was a classmate of my father, and Sri M. Gopalakrishna, former chairman of SCOPE, very many eminent members of the audience present here this evening. As I was being introduced, it was mentioned that I've had a long career in the civil service at 35 years. And in most audiences, I would mention that with a certain amount of pride. But to be very honest, as the author of the book mentioned today, he claimed to be the oldest member in the room. I can almost, lay claim to be the youngest member in the room in some ways, and definitely on the stage. But, and quite honestly, the last time I actually lived for a length of time in Hyderabad was as a school student. And today, I almost feel like I'm back as a class 5 student in Little Flower High School. It's simply because, the members of the audience are, some of them have known me since my childhood days. Some of them have seen me through various stages of my career. And some of them have known me through various other stages. Two of the very eminent members are former predecessors of mine in the present ministry. The last time I spoke about a book release was about Dr. Y.V. Reddy's memoirs release in Chennai, and he's present in the audience today, and it's a delight to see you, sir. And from almost every angle, the audience is honestly so eminent that I haven't actually felt so nervous speaking before them. I think the last time I felt this nervous was as a school student. But having said that, I was Dr. Chakravarti requesting me to release this book, and the amount of planning that went into this and the amount of effort that went into it is something that is truly to be admired. When I joined the civil service and I was trained in Coimbatore district of Tamil Nadu, one of the early weeks, I went to a BDO's office for training. I'm all of 23 years old at that point. And the BDO tells me that the most important thing in service is to retire peacefully. So, at that point, it never made any sense to me. Now, as I reach the end of my career, I think it makes a lot of sense. And I mean, the sense of camaraderie I see here today, the fact that so many former retired civil servants have turned up, retired friends of the author have turned up, and they're all together here today gives me a lot of hope. Because sometimes I wonder, when you wind up all this, you have busy days, and when that finishes, what do you do? And really, the models, the role models who stood before me for many years of my career continue to stand before me as to what one could do. So I deem it a real signal honor to be present here and speaking before. Coming to this entire subject of privacy and entire subject about protecting information, I think I should relate another personal anecdote and actually thank a person who is also thanked by the author in his foreword or his preface of the book, his brother, Mr. Sridhar. It was mentioned that I was posted in the International Monetary Fund for a while. So I once went to visit his brother near Washington. They used to live in a suburb of Washington, D.C. in Virginia. So I went to visit their home, and I was quite surprised to see that he had an actual shredder in his home. And this is not maybe 20 years ago, not about 17, 18 years ago. He had a shredder. So the only time I had, my father was a police officer. He was in the intelligence bureau and so on. So I was quite used to seeing the shredder. I mean, they used it for their own purposes. I used to have it when I was a district collector and when I was a budget officer in the government of Tamil Nadu. I had a shredder because we kept shredding official papers. And I was wondering, why would you need a shredder at home of all places? He said, no, it's very important because there could be identity theft. Because we get a lot of junk mail. We get mail with names on it. We get mail with addresses on it. Even if I throw it out, even if I tear it and throw it out along with my trash, somebody can piece it together and figure out my identity and figure out what can be done with it. Yeah. Exactly. With the boarding pass, there are so many details which are present on the boarding pass and so on. So he used to shred practically every mail which had his address or personal details on it. And that's the first time I really became aware of it. And it's interesting and it was important. Till date, and this was in 2007, that I applied for and got an American Social Security number for the duration that I was posted in Washington. It arrived at the residence because I just joined there. I didn't have a permanent address. So one of our colleagues in the IMF ED's office, at his residence, this particular document went, and it was somewhere in Alexandria and Virginia. To date, I get emails saying, Alexandria, Virginia, such and such a thing is happening. You better take care of your personal reputation because there are so many predators there. Somebody else is there. Someone has committed a crime. This is to the extent to which personal identities can be stolen. This is a way in which it can be misused. The example that was cited in the video conversation, which so evocatively told us how privacy can be abused, is almost true. And it happens on an ongoing basis. But unfortunately, I think the awareness of what can happen is new. Now, I used to be finance secretary of Tamil Nadu at some point, and we introduced, and I thought it was a great scheme, the integrated financial and human resource management system, saying we'll computerize everything, we'll put all the data together, we'll get everything together, and about 60% of government expenditure in any case is on salaries and pensions. So the human resource management needs to go alongside it. Many decisions will get automated. We did all that. We conceptualized it beautifully. It got put together very beautifully. Then once I went to a sub-treasury in a village or a place, a town called Kumbakonam, which also incidentally is in the dictionary as a term to denote, how twisted something can be. So, and I was sitting in the sub-treasury officer's office saying, okay, reviewing what is going on and how they were operating and what he was doing and so on. And I asked him saying, okay, all this has been done, and I'm sure it's very easy for you to pass bills now and do the entire operation very systematically. Can you just demonstrate to me how you're doing it? So this guy was sitting in the seat, just promptly got up And he called a youngster, a contract employee who must have been 22 or 23, who was standing somewhere in the background. He said, put in my password and login ID and password and start clearing all these files. Now, this is what happens. And this is, in a sense, what happens in our country. In all of this, we do not worry much about username, password ID. It's behavioral. We are perfectly happy to share so many of these identity points. And then I realized that this was the biggest weakness in our system, the human element of it. He just shares it and somebody else can do it. This is something which can happen both in a government system and in another system. My wife had an account in State Bank of India. And one day she got a call. This must have been when they had introduced all their centralized banking and everything else. One day she got a call saying, by mistake, we have deposited some, and those days it was still a big amount, 1 lakh of rupees in your account. It actually belongs to somebody else. This is informing you that we are transferring it back into the other person's account. And they went ahead and did it. And she was like, how can they do this? Because tomorrow they can just transfer anything, any which way, even if it didn't get deposited in this fashion. Somebody has control over the way that this entire thing can be done. This is one problem of systems of this nature, and this is one problem or one way in which levels of protection need to be provided to ensure that we are protected against not just bona fide mistakes, but actual malafide malicious acts, which many of us can take. I wanted to highlight this because very often we do not bother about this. One of the issues in social media really is the amount that is shared voluntarily. We do not look at it as something that we shouldn't put into the public domain. Very willingly, all kinds of pictures, vacation pictures, everything. I mean, we are sort of living life right there on the stage for somebody else and as opposed to ourselves. So valuing privacy is important from a number of perspectives, and that is something which I think fundamentally starts with behavior and fundamentally starts with cyber hygiene, and which is why Dr. Chakravarti's book is so important. What governments can do, the way they can be restrained through law, is all one part of it. India is a nation with many, many laws. And many, many laws, as we are aware, are rarely implemented. We have eminent jurists here. I don't know whether they'll agree with me. I spent 2 years in a law college, but I think the fact that we have very many laws which are rarely implemented is well recognized. And that means that just by having a law, we will not be able to protect. The awareness of what needs to be done and people demanding that a law needs to be implemented or if action needs to be taken is very critical. And what the book really does is raise that kind of awareness, enable people to demand that there needs to be a framework to deal with this, and the framework should be worked and the framework needs to work. So that becomes extremely important. Sometimes I wonder, today the case was mentioned of the Vardhaman chairman, or Mr. Oswal, who was seated in one of these standard cyber arrest scams. What is it that leads to such people getting cheated? I mean, eminent people who would know what the law is and aware of what it is. Sometimes the cheating happens due to sheer greed. And I know of cases like that where well-educated people make investments on very little known sites on the basis of some WhatsApp group information and so on, and make large investments and suddenly find, and they chase high returns and they get into trouble. This is greed of the highest order. This is ultimately confidence strips which have been going on from God knows where. I mean, anyone who offers to double your money, we tend to sort of make that investment and put it in. So that is something which happens all the time. Equally, sometimes, probably there's a guilty conscience. Probably they feel that they've broken the law somewhere. But more importantly, probably they think they may have broken some law. And they're not sure. I mean, there may be a law that we have broken. And in India, the principle really is lack of knowledge of the law is no defense. Therefore, you presume that I may have broken some law. This guy might be speaking the truth and he's fall for it. So it's a confidence trick which can really only be combated through awareness. Only problem is with technology, the means of carrying out these confidence tricks are much easier, and the damage that they can do to you is also significantly more. And hence, there is a heightened need to be aware and a heightened need to protect ourselves as individuals in all of it. Now, the Digital Personal Data Protection Act itself has been enacted in a way so that it is done as a simple piece of legislation which anybody can understand. The language is intended to be very accessible. And, that is another feature of Dr. Chakravarti's book, which I really appreciate because, he's written it in a very lucid and in a very accessible style. And to illustrate many of the points, there are many cartoons, many drawings, many other ways in which the same point gets made again and again. And I think it's an easy way to illustrate a point anecdotally and otherwise to get across the real concern and the point that is there. Similarly, the law is meant to be written simply. We have tried to put in illustrations, many illustrations in the law. As I mentioned, I went to law school for 2 years, and I was told at that point that the Indian Evidence Act is probably the one enactment which has undergone the fewest amendment in its almost now 160. Of course, now the whole thing has been replaced, but till it was replaced, it had undergone the fewest enactions. And many of the provisions of the Indian Evidence Act, including the way documents are defined and so on, continue to be relevant even as technology changes. And the old Act would have all of these examples which are given, illustrations which are given as to how AIDS said this to be, and therefore this amounts to hearsay and so on. Now, we've followed almost a similar approach in the case of the DPDP Act. There are illustrations which will show what needs to be done. The idea there is to make it simple, accessible, and understandable so that more people can actually use it. Try not to cross-refer, notwithstanding anything contained in so-and-so legislation. There's no non-obstante clause. All of it is direct in terms of what the legislation itself prescribes. We've also, one of the problems often, and we used to have, and I think some of the members of the audience would also possibly recall, there used to be a professor who used to teach us law, who was a former district judge of West Bengal. Not just Pathak, Dada Banerjee, Durgada Banerjee, D.D. Banerjee. And so the one point that he used to repeatedly make is it's not the severity of the punishment, it's the certainty of the punishment which is more important. And that principle basically means that if you have a very severe punishment prescribed, courts would be less inclined to sentence a person, and especially if it involves imprisonment. And so that's something, again, the Act avoids. The Act avoids severe penalties in terms of criminal penalties, but what it does is, in the contemporary world, we understand monetary penalties much better. So the penalty which is imposed for breach of the law actually takes it up to almost 250 crores. So the breach involves penalties of up to 250 crores. And interestingly enough, and this is important, and I think as we should spread the word amongst various government departments also, government departments have no protection. And they are also bound by the law. And if they store data and there is a data breach, they could be liable to similar punishments. Of course, various other principles of the law, including the fact that data can be stored only based on consent. There is a data minimization principle. In fact, in the book, Dr. Chakravarti does mention that data minimization hasn't been addressed. I'd just like to humbly correct him, saying that there is a provision on data minimization. Section 6.1 actually says that you shall not collect any more data than is required, and you will not store it for any duration of time beyond that. So there is a requirement that you have to purge the data once the need to store it goes. So the principle of data minimization has been observed, and the principle that it needs to be purged has been included. And I can assure you that
clearly the people who are most worried about the law are the large companies and the corporations. They are the ones who have been coming back to us repeatedly saying, how will you implement this? How will you implement that element of it? Clearly, they are concerned. Clearly, they are looking at ways in which it can be complied. They also believe, and again, in the way that the book has been organized, is, what are called spaghetti westerns, the good, bad, and the ugly. And some of the better features, or the good features, which have been pointed out by the author, include the fact that a collection of data can do so much good for people. And clearly, in the Indian context, there's so much, so much we have been pushing over the years on database governance and evidence-based policy making. There's so much talk of all of that. And suddenly, if you don't have data, then how will you do it? Is a big question that arises. And very often, one of the critiques of Indian administration is that we don't base a lot of decision making and policy making on data. But clearly, using data is useful in its own way and needs to be brought in its own way, provided there is consent, provided that it is used in a way that is fitting. So to that extent, data also has a lot of scope for innovation, and a lot of it in terms of today when we use Google Maps, how does Google know that traffic is backed up in some particular point, and it is going to take longer for you to go anywhere because they collect the data based on where your phones are currently and how fast they are moving. So there is clearly data collection which is going on all the time. Some of it may or may not be personal data, some of it may be anonymized data, but there is certainly some good which comes out of the way that data is collected and it is used and analyzed. Therefore, we can't throw out the baby with the bathwater. And in a number of other fora, many people have commented that India's law actually balances the need for innovation with the need to protect privacy. And we have attempted that particular balance. And at the same time, the concern that many large companies and others have as to how exactly the act will operate and how exactly they will fall in line with various provisions gives me confidence that this is a law which will achieve the intended objectives, get us where the Puttaswamy judgment, which underlines the right to privacy as part of the right to life and right to personal liberty under Article 21 of one of the founding features of it. I'm sure that it will help us achieve those objectives. And of course, as with every other right in our Constitution, there are reasonable restrictions, there are reasonable variations based on consent and all of that which has been provided there. And I'm reasonably confident that when the rules come out, and of course, mention has been made that the act is not yet come into effect and the rules are yet to be notified. I can honestly tell you that the rules have been drafted. We've dotted the I's and crossed the T's. We're just awaiting the final stages of clearance. And we do hope that we should be able to notify the rules fairly quickly. And even after that, there will be some time of transition before the rules come into effect. And there will be time also when the rules come out for many people to comment on the rules. There will be about 6 to 8 weeks within which comments can be made on the various provisions that have been included to make sure that the issue is fairly and squarely addressed. And I would again request the audience present here, request ASCII, request the author and everyone else to use that window of opportunity to actually give us your valuable comments and your insights on what features of the rules need to be looked at and how it needs to be addressed. So I think, I know that, we've had a long day. There is a panel discussion to follow this. I do not want to sort of speak about more elements of the book. There is a lot more that I would have loved to have commented on. I have had occasion to read through most of the book and look through most of it. It makes a very interesting read. And I only hope and pray that at his age, at Dr. Chakravarti's age, I would be able to, even put my mind to putting together something of this kind. I think it is remarkable. The congratulations are really due for that. it is truly a superhuman effort from that perspective, and I'm very confident. I joined the chairman in wishing that there's not one, but at least two more books which will come out of his quiver in the days to come. And I thank you all. Thanks the audience for a very patient hearing. Thank Dr. Chakravarti for having invited me, and ASCII for having hosted me. And the biggest delight of this evening, the opportunity to meet so many of you, so many respected seniors in the civil service and elsewhere who have, in a sense, been role models in the past. And I'm sure what feels nicest is that they continue to remain role models even at this stage. Thank you very much for this wonderful evening.
Thank you very much, Mr. Krishnan, for your comments and remarks regarding the book and placing into context the DPDP Act, and giving us a perspective on the relationship between all of these parameters. We now have a panel discussion. We have three distinguished members who will offer their thoughts and comments and views on the book. So I shall begin by requesting, and before that, I'll just give a brief intro to Professor Sri Krishna Deva Rao, who is the Vice Chancellor of Nalsar University of Law in Hyderabad. His work is Vice Chancellor of NLU in Delhi, NLU in Orissa, also Gujarat National Law University, National Law School, Bangalore, prior to being here in Nalsar, Hyderabad. Also the recipient of the Dr. J. Kumarappa, Dr. Walter Reckless Award for his outstanding contribution in criminal justice education in India by the Indian Society of Criminology a few years back. And he's also represented India at the UN Human Rights Council at Geneva. With that brief introduction, I'd like to request it's your call, sir. It's your call. Yeah. The request, Professor Sri Krishna Deva Rao, to kindly offer his views and thoughts. You may do so, sir, while sitting there or up at the podium. It's up to your, whatever you prefer. In which step? There's a great learnings of since last hour. What I would briefly would like to throw 3-4 ideas, particularly important 4 issues. Some of these have already been discussed in detail about this book. Let me begin with the title of the book is a conventional style of somebody looks at more closely. I think the author already has explained about the title, but I look at as some of the preliminary thoughts, like when we look at the privacy law, as we look at privacy law is just of a recent origin, 2017. Data protection law was the one of the major, the 2017 judgment visualized. It took some time, and now the rules are ready. 2023, 2024. Krishnan has assured, promised that it will be coming very soon, maybe 2024 or 2025. Trust I am looking at is optimism, which the author in these books explained about. I think that was visualizing right to privacy as a major trust, a new right for the future. That's what I would look at as a trust.
Overreach, he said about bad, ugly. Overreach, I could see pessimism, or what we look at is some way of skepticism that I could also visualize. I also look at. So privacy and data protection created an enormous trust among the citizens, and the future is a data protection. Secondly, its overreach and possible erosion may be a future path. Hopefully, data protection law, new rules, as the government of India is looking at, simplifying, demystifying, everybody must understand, not only the corporations, government, educational institutions, everyone has to do a lot of training, orientation, and development of this, because this is going to be a future with the artificial intelligence much more as the pessimism or a skepticism we could see, but trust develops optimism. And future path towards the overreach and erosion is skepticism. Hopefully, more rules will be able to. I will not go into Puttaswamy case, which we have discussed in greater details, but I would look at Puttaswamy case as some of us, we have been dreaming about privacy law for many years. This we would look at what some of my colleagues say that pro-privacy era that was started from 2017. Privacy-friendly jurisprudence was inaugurated 2017. Three part of test of privacy already we discussed about: legality, necessity, proportionality. I look at something which is a fascinating from Chakravarti sir idea is about he is looking at how aligning the data protection law from ethical principle. I think that's what I look at a future jurisprudence. People started in the age of AI, they are saying pro-human approach. So pro-privacy, pro-human approach, how do we align data protection law to use with ethical principles? Is it rights-based framework? We have to look at that. Respecting autonomy, dignity, it must recognize data privacy. Already it is a fundamental right, but allowing the individuals to control over their personal data. Example, the author mentioned about European GDPR, which emphasizes on principle of consent, purpose of limitation, data minimization, Krishnan has mentioned, ensuring data use, respecting individual rights. Something which is another very interesting is about the other aspect is intersection between privacy and competition law in India. I will say very briefly that Competition Commission of India has started examining cases where privacy violations may constitute abuse of dominance under Section 4 of the Competition Act, and also the interplay between the Competition Commission of India and proposed Data Protection Authority will be very crucial. We have to wait and see. Coordination is necessary to ensure that privacy enforcement complements competition policy. I will not go into the case studies and other. Lastly, two issues I'll just touch upon, and then I'll ask the other panelists to proceed. Last one is the widespread cybersecurity is there. There we have about cybersecurity is not just only a organized crime, super organized. The World Economic Forum's Global Risk Report said that cybersecurity is one of the top 5 risks of humankind over the past few years. So this is an intersection of law, technology, and the future path towards how do we respect the pro-privacy law in the coming year. Lastly, widespread education is required. The several new courses needs to be developed, several new programs, interdisciplinary programs needs to be developed. I think after coming to Nalsar over the 2 years, this is the first time I'm visiting, and grateful to Director ASCI for inviting me for this. Now, ASCI and Nalsar will, with the help of the Government of India, will start developing new interdisciplinary courses. This requires a massive awareness and providing future tools for the protection of data privacy. Thank you for giving me the floor.
Thank you, Professor Sri Krishna Devaragal. I now request our second panelist, who I will just briefly introduce, the Honorable Justice T.N.C. Rangarajan Garu. After having almost 15 years in the working for legal firms, he was appointed as a judicial member of the Income Tax Appellate Tribunal. He has then served as the Vice President of the Income Tax Appellate Tribunal South Zone, later appointed as a permanent judge of the High Court of Madras, and then subsequently the judge of the High Court of Andhra Pradesh. Sir, we request you to give your thoughts and remarks on the book.
Thank you, Kenneth. Actually, I had the privilege of having a glance through the book before I came here. And what was fascinating is that he has put a very, very difficult subject in a very easily understandable presentation with cartoons, with the jargon, and with very catchy pieces. Any ordinary person normally will get a little confused when you have a complicated subject as in a book. If the philosophical book or a legal treatise is not an easy thing. But his book is very readable, very impressive, and very understandable because of the cartoons first. And today also he has shown you the video. The video shows the trigger point for the book. And that video makes me play the devil's advocate. Now, everybody has been saying about this Supreme Court judgment as privacy as a fundamental right. Now, I wanted to say that in our legal system, we have the public law field and the private law field. The question of fundamental rights comes only in the public law field, where we have to deal with the government or government instrument. In the private law field, any information that we have about ourselves is only a kind of property. You can call it an asset or a property. And as with any other property, it depends upon how careful you are to keep it to yourself. Now, I am also reminded of the Johari window, where you create the persona. You broadcast what you are, your address, your name, for instance, if I am a left-handed person and Google knows it, they may bring out a left-hand spanner. The thing is that commercial ventures are always interested in finding out a need and fulfilling it for making a profit. So in this scenario, if you are going to block that information, you are only going to block the information which can lead to some benefit. Is it necessary to do that? This is first question. The second question I want to raise as a devil's advocate is, if you are blocking that information, you are actually trying to transfer what is in a private law field into a public law field by creating a crime or an offense which is punishable under law. Because criminal law is public law. Contracts and torts are private law. So as long as we are keeping it in the field of contracts and torts, we do not need any of these punishments. It's only a question of injury and compensation. But once you bring it to the public law field and make it an offense unpunishable and with very enormous penalties and running it to court, obviously they are all addressed to very big ventures. Ordinary people are not, how are they going to, for instance, when I go traveling as a mess, I need a bottle of water. I'm thirsty. I have to tell somebody that I'm thirsty and get it. If I tell that I'm thirsty in some place, and that another two shopkeepers come to the office. There may be a competition to supply. One may supply water, one may supply fruit juice or something, and there's a competition there. Security is better expert in that field. So when that competition comes, how is this data going to affect that competition? It's actually the data is going to encourage a competition. So that is the sort of different sort of thing I just wanted to show it in a different perspective. Just to see that I'm different from an approach which can be used by security for its textbook. Thank you.
Thank you, Justice Rangarajan Garu. And now request our third panelist, and I'll just introduce him briefly. Distinguished civil servant, Sri M. Gopalakrishna Garu. He has served in the government of Andhra Pradesh, government of Assam, and government of India. Served in many public sector organizations, chairman of Rural Electrification Corporation, commissioner of Visakhapatnam Steel Plant, and also he served as chairman of SCOPE, is a standing conference of public enterprises. Sir, we'd like to request you to kindly give us your thoughts and views on the book.
Thank you very much. First and foremost, I would like to compliment and congratulate Chakravarti for actually taking up this job. And I know how much effort he has put in to see that this book is published in a nice manner. I would like to begin my talk very simply that the right to be left alone is privacy. The right to be left alone is privacy. And that is actually determined as a fundamental law. And it is fundamental right that is guaranteed by the government and the Constitution of India. Apart from that, we have also got in other countries the same thing, that you have to respect the individuality and the privacy of each and every one. So this is the thing that we have. So therefore, what we need to actually look at is there a distortion of truth that is taking place? And if so, through what means it is taking place? And that could be through social media, it could be through data distortion, it could be anything. But what is important is that the right of privacy to be left alone is being actually violated. So how is this violation taking place? And what is the nature and degree of this violation is actually very important for us. The other thing is the sanctity of the person, the sanctity of the family, the sanctity of the relationship. All these things get violated when we are talking in terms of data distortions that are actually taking place. And that is the cause of a lot of misunderstanding, mischief, and hardship. The other thing that I would like to say is that there is an erosion. He has talked about erosion. There is an erosion of ethics. There is an erosion of values. There is an erosion of trust. There is an erosion of truth. And there is an erosion through technology. All these things are happening place in respect of the data. And my friend Chakravarti has been earlier a member of the MRPC. So he is very familiar with monopoly. Now he has to get familiar with data police, because there are so much of data like in a monopoly. Now this is practically becoming a monopoly. So in which case, how do we deal with it? And since Mr. Krishnan is here, Secretary, I think this point is known as to how government can also step into this picture. So this is one thing very, very important. Now we always used to say corruption is the use, the abuse, the misuse of anything for private gain. Now, this is actually misuse of data for private gain. So you have to see in what way the punishment should be, like in the case of the corruption cases also. One very particular point is that you have to see that it is worse than corruption because it's a catastrophe. Catastrophe in many ways. So that point, I think we should actually keep in mind. The other thing is now a caste survey is being done. So now we do not know what type of information they're asking and for what purpose they will be used also. So we need to be very careful about how this is to be done. And next is, is it being scrutinized? Who are scrutinizing it? That is very, very important. And the book actually, he had given me to go through it. I found the book is very interesting and it's path-breaking in several respects. And it also captures the essence of privacy in all its aspects. It cautions us about the need for proper drafting of the Act and the penal provision. And this becomes very important because today, what is happening with the monopolies in the data procurement and use is now making it universal. Will our laws really affect it or not also becomes important. And we have to also look at the limits of privacy and autonomy in a democratic and welfare state. And most useful, I think, is this book will be most useful for advocates. It will be most useful for law students. And since our vice chancellor is here, I think this he should actually tell his students also who are interested in this to actually purchase this book. Libraries, universities, law colleges, all these things are very, very important. I do not want to take much time because normally when I start talking, I can talk even for an hour. But I don't want to do so because already all of you have heard enough about the importance of this thing. The only question is, in what manner can individuals control it? In what manner institutions can control it? In what manner the government can regulate it? These are the things that we need to do. And I once again thank everyone and my friend for last 60 years. We have been friends, and therefore he used to ask me many things. So I think he used to exchange notes. So I'm extremely happy that the book has come up. Privacy rights and data protection is, and also the trust, overreach, and erosion. As long as the trust is correct, I think things will be all right. So otherwise, what we all need to know is there is a Sanskrit sloka. The sloka says, Chintaniya ipadam adavera pratikriya na kupa kananam yuktam bhaktinasi. You must be aware of things in advance. There is no point in thinking a well at a time when your house is on fire. So let us prevent the fire in first place and also have the preventive measure of having a well ready in case you have to douse the flame. I think with this word, I thank once again Mr. Chakravarti and all of you for whatever little things I can say. Thank you once again. Thank you very much.
Thank you, sir, for your comments. We'll now have a short Q&A from the audience. So kindly, if you want to ask a question, kindly raise your hand. And then when I call upon you, just introduce yourself, keep your question brief and to the point. And you can address it to any member on the panel, the author, the other dignitaries who were earlier on the dais. You can mention who you desire for to answer the question. Sir, please go ahead.
Sir. Good evening, sir. I am Damodar. I'm a retired IG of police. My questions are addressed to Krishnan sir, Secretary of my team. I have 3 questions, sir. After all, our DPDP Act has largely drawn upon GDPR of European Union. Why there is so much of delay in notifying it? Even after 15 months, we have been eagerly waiting for it. A. B. The earlier draft and DPA was withdrawn because Justice Sri Krishna whose report after the judgment of Puttaswamy's case is the basis for drawing it. Particularly, he opposed it on too much of exemption, too much of patronage being given to government agencies. How these 2 concerns have been addressed in the present DPT Act. After that, I will come to the 3rd question.
The first thing I think, yes, you need to sort of try and get it out as quickly as possible. That point I can see. But oftentimes what happens is, I think, when we are making policy and it is complex and it's a new law, it's worth spending a little more time on the drawing board and consulting a wider cross-section of people before we sign it. The ministry has been working on multiple drafts and there's been repeated consultation on this aspect. Like I said, our portion of consulting with all the relevant stakeholders is done, and it's a final process of, given the sensitivity and given the importance, we need to sort of make sure that all the the political executive is also to be taken into confidence before it is done. So that process of consultation takes a little time. That is in the nature of government, and that is where we are. The second question is, I think our act in a number of ways actually moved away from the GDPR. We are not identical. GDPR, in fact, even within a month of my joining the ministry last year, I was at the Swedish ambassador's event. There was a minister from Sweden who had come, and they are part of the EU. And one of the points that he made to me is that it's very fortunate that you have taken a different and a fresh approach in the Data Protection Act, which is distinct from GDPR, because in Europe, we have tied ourselves up in knots, and many of the countries in Europe themselves are opposing it, including Germany and France and Sweden and so on. So from that perspective, I think the feedback that we get is we struck the appropriate balance between innovation and regulation as far as this law is concerned. And we have not, I mean, there are elements of GDPR because ultimately, when we are legislating on data, some of the principles are similar, but in the way that it has been balanced, I think we have struck the appropriate balance.
Justice Sri Krishna's remark, and the too much of importance.
I think I addressed that in the course of when I said that government agencies are also not exempt. And in fact, some of what we are trying to do in this entire process is to actually, we've been doing a lot of workshops in this interim period before the rules come out to educate government departments and ministries of their responsibilities of the act. Because, budgets will go bust if if there are data breaches and we have to pay out those large penalties. So I think that is something that we are acutely aware of within government, and we are educating many of our people under that.
The third question to you only. This is important. Contemporary Elon Musk entry into this country, because privacy is intertwined with security. Now, Mr. Elon Musk is trying to enter SATCOM. Leaving aside the commercial concerns of the Indian operator, there are many concerns from others, particularly law enforcement officers. If we control satellite from there, we are all operating in a separate planet called cyberspace, Maya Prapancha, not this planet. If he switches off satellites, will it not become a technology imperialism? This is an extreme fear being voiced. As of now, we as law enforcement officers are finding it difficult to get the information from the Indian operators. Thank you, sir.
On this particular point, I mean, I'll be honest with you. I do not want to answer this question from an official perspective because I am speaking as Secretary Navy because it doesn't fall within the remit of my ministry. It is controlled in the Ministry of Telecom, in the Ministry of Communications and the Department of Telecom. So it would really not be fair for me to take that question on and answer it. I have a personal opinion, which I am willing to share with you, sir. Thank you.
Thank you. We have a question. Yeah, please go ahead, sir. Just introduce yourself.
Good evening to all of you. I'm very happy to be here, delighted to be here on the request of Mr. Chakravarti. My name is Anantran. By qualification, I'm a chartered accountant. I also happen to be the son of Mr. P.L. Shivaram, IAS, who retired as the Chief Secretary. And it's been like meeting all of you is like remembering my father and the warm affection. And I'm feeling very delighted to be here to be amongst all of you. My question is to Mr. Secretary and to the panel. Whosoever two issues I want to ask. One is with reference to the new social media thing that is coming.
and all these social media companies are getting into the details of the children and sending them all kinds of things. I have not read the book, nor am I aware of the act that you're talking about. I'm just raising these two questions, whether these two aspects have been considered by the government of India. One is the impact that the social media people are doing on the children in terms of getting to them and sending them all kinds of horrible messages and something like child pornography, stuff like that. Is there any act, any deterrent that has been made in the act to prevent such kind of things? That is one question. And the other question is, of course, in terms of the artificial intelligence that is all bound to take over now, what is the act talking about? If if there is a company and the company has given away the data to some other company which is doing artificial intelligence, and the artificial intelligence is the prime mover of going to the concerned people and collecting data and doing all sorts of damage. Is there that provision taken into, because tomorrow or day after, we are all bound to be into this artificial intelligence kind of a thing. Artificial intelligence is going to take over the whole thing as we are all. I don't want to get into the subject in detail, but what I want to know is there any discussion or any deterrence to companies to say that, look, it's not my problem. I gave the data out to somebody and that some company is doing this damage. So it's not me. So I just wanted to bring these two points. Thank you so much.
Let me quickly address both these questions. The first question is on social media and its impact on children. There are two parts to the answer. One part to the answer is something that you mentioned in terms of child sex pornography and so on. Already there are restrictions under the IT Act on carrying this kind of material, and there are various deterrent provisions under the IT Act which are being extensively used to prevent this. In addition, the IT rules were amended in 2021, and they are required to take down such material even before they see it. It's interesting, and this is data that we watch, and they are expected to publicly report how many takedowns they've done on the various categories. And you'll be gratified to know, and I think it's important data for this audience to know, that what the government orders as takedown, and there are three provisions which are applied. There is one which is Section 69A, which mainly operates in terms of blocking, and that is under very limited circumstances, which is public order, security of the state, and so on. There's another provision where there's an offense which is committed, where various state governments, law enforcement agencies, and others can act, which is Section 79(2) and Section 79(3) of the IT Act, which is extensively used. But in addition, because the IT rules now require, they have a due diligence guidelines which are issued, and the social media intermediaries are required to act on the basis of those guidelines. And under Rule 3.4, they are required to publish also how much action they've taken. And recently we looked at that data. Somebody like Meta has taken down almost, or this Facebook has taken down almost 2 crore such objectionable content. And the total number that government has actually ordered them to take down, that is, MeitY has ordered them to take down in that same period, was less than 1,000. So there's a large volume, and there is significant significant way in which this can be done. The process of doing it is also very simple. If you ever come across content of this nature, you can make a complaint to the grievance officer, and it will be done immediately. If it is not, you can bring it to our notice. And that is an issue I can honestly say is more or less under control. The problem in social media is not that. The problem in social media is where there are political views and, slightly different perceptions on that. But on things like CSAM, as it is called, and the present practice of controlling that has been fairly effective, because most of them have also fallen in line, and we need to recognize. Under the DPDP Act itself, there is a provision for verifiable parental consent. Without the consent of the parent, you cannot open an account, a social media account, for anybody who is under the age of 18. And the companies are required to adhere to that. So that issue is also addressed in terms of their presence in the social media. And I think it's useful again for the audience to know that this is a measure which is being taken. The second question related to artificial intelligence. See, it's a much broader question and we can go on, but the point here is that the main feature of this act is that personal data can be used by that entity only with explicit consent. That actually answers Justice Angarajan's point as well. If I believe that my data, sharing that data would be of benefit to me in terms of, getting better services from 3 or 4, you can share that data, but it is with your consent. It can't be done without your consent. If on the other hand, you want to exercise your right to be forgotten, or you want to exercise the right to be left alone, that is the point that Mr. Gopalakrishna made, then you can sort of exercise that right and say, don't trouble me with this. So there is a specific consent which is now being sought in a mechanism. So for use of personal data in an AI situation, consent becomes the important thing. And if consent is provided, then the data can be used. Otherwise, it cannot. So that is the protection that the Act offers. Thank you. Yeah. That's right.
Any other questions? Yeah, there's a question here, please. Is it better? Okay. We've spoken of consent and privacy as we relate to living specimens of what we do in our daily life. I'm just curious, what will happen to us after we pass away? Now, we store an enormous amount of data. Who is the steward of that data that we have created online after we move on? So, for example, all of our private data is outsourced to large platforms. So hypothetically, a historian 100 years from now would like to study how the DPDP Act under the Fishman was envisaged and look at all the tweets and its history. And all that is privately controlled by platforms. What is the thought process going forward in terms of managing the data in the afterlife? I'm just curious. It is called legacy. I'm just concerned about issues of access, issues of encryption, issues of transfer, because today there is a method by which paper records, land records are transferred through something. What happens to data?
I think one element. See, every issue doesn't get addressed as a privacy issue under the data. You need to be cognizant. But again, as a part of a data minimization principle, there's a requirement in the Act that says that once the need for the data ceases, the entity is bound to get rid of it. The company is bound to get it. Which means if the data is no longer required, they have a duty under the Act to actually get it. So your data is no longer required, and presumably there would be certain elements of your data which would no longer be required. Procedure to remove.
They find out whether the person is alive or dead, and then they even have a earlier consent to transfer it to his son or whoever is nominated.
That, of course, from a consented son.
Non-consent transfer to the legacy. It's called legacy programs.
Maybe one more question if there's a hand raised on that side. No? Okay, last question, please. Yeah, go ahead, sir.
Yeah, my name is P.V. Ramesh. I'm conceptualizing electronic health record framework. So I would like to know, has this act considered that at some point all our medical data may be in digital format? And today it's vastly different. Today it's mostly in paper. So have you considered that? And if I'm developing an EHR type of application, what type of guidelines or checks do I have, controls, things like that? Is there anything, any document like that that you have published?
Yes, I mean, of course, we believes that, and that's the whole purpose. A lot of the data will be maintained in electronic format, and in certain jurisdictions that is already started. The formats and the safeguards that are required is something that the rules cover, and to some extent the Act itself covers. Maybe offline we can discuss, or I can get somebody to explain to you the relevant rules, which it may not interest the rest of the broader audience, but you should also wait for the rules. So once the rules come out, you will get an idea of how the data.
Thank you for all your questions and also for Mr. Krishnan and others who have answered these questions. Now we move to the last item in the program this evening. Before that, I'd just like to mention that for those of you who are interested in purchasing the book, it's available outside. It's set up on a table. So Ms. Sandhya is sitting there and she can help you with your processing. Now we will have a quick presentation of mementos. For that, I request the chairman, Shri Padmanabhaya Garu, to present a memento to our chief guest, Mr. S. Krishnan, and to the 3 panel members. To request the 3 panel members, Shri Krishna Deva Garu. Request Justice Sangarajan Garu to come. And Shri M. Gopalakrishnan Garu. Thank you, sir. And finally, we shall have a vote of thanks. You want to come?
Mr. Gopal Krishnan saying that this book must be read by all lawyers and law students and all that. And 2 eminent side and here, they said the book is available now. It's priced at about $7.95. But for today, we have decided that it can be sold at $6.99. So there is a concession. So in case you want, you can take the books, So that's what I wanted to tell you. So that is it. Krishnan sir, I wanted to ask you a small question. You mentioned about that shredder in your friend's place, where he used to shred all the papers. Now that it's all digitalized, I delete something, but I believe it remains in the computer forever. Yeah, there are a lot of complications, Thank you.
So as chairman pointed out, there's a special discount today. So if you're interested, lady sitting outside. Finally, I would like to request the Director General of ASCI, Dr. N. Ramesh Kumar Garu, to propose a vote of thanks.
It's my pleasant duty to propose a vote of thanks to the distinguished panelists for the time, for the effort, and also for the enlightenment they gave us. Vice Chancellor Krishnadeva Garu, Justice Rangarajan Ji, and P.M. Gopalakrishnan. And particularly, we would like to thank Dr. Chakravarti for giving an opportunity to really publish a magnum opus on this subject. This is an evolving platform. This will be one of the serious intellectual effort which would throw light, and it is necessary. And in the end, we thank all of you for your very gracious presence. And I would be failing in my duty if I don't acknowledge the effort taken by Mr. Krishnan to come down here. He is such a busy man. His time is valuable. But what I would like to remember is his humility, his openness, and his willingness to share his knowledge with us. It made a very deep impression on us. Thank you very much. Good day.